Now let's get expert insights into the court order concerning the suspended Kogi Central Senator Natasha Akpoti-Uduaghan. I'm joined by legal practitioner Liberus Oshama. Thank you for joining us, sir. Now, help us understand this ruling, because the court emphasized that the 6-month suspension effectively silenced Senator Natasha's voice in the Senate for nearly the full legislative calendar. Is this also a violation of her constituents' constitutional rights?
First and foremost, quickly, let's understand a few things, because I have been reading reports online, claiming that the court asked Senate to recall Senator Natasha. We need to understand that when matters are in court, the court is not a Father Christmas. The court will not grant you prayers that are not requested for. As at the time this matter was originated, if you remember, as at that time, Senator Natasha had not even been suspended. What went to why Senator Natasha went to court was her matter was referred to the Senate Standing Rule for disciplinary action, and so she rushed to court to enforce her fundamental right, which was why the Senate also filed a preliminary objection that Natasha that the court does not have jurisdiction, that the matter was preempting, and the court ruled that to protect fundamental rights, you don't have to wait for the action to take place. And so in that case, that the court had jurisdiction to hear the matter. And then the court also heard that the Senate had powers to deal with erring members, that the Senate had powers within its rules to deal with the erring members. But the only area was that the court frowned at Chapter 8 of the Senate Standing Rules and Section 14 of the Legislative House Powers and Privileges Act, where the court labeled it as overreaching and excessive for failure to clearly define a limit or duration of this legislative suspension. And so what that means, if you will listen to Aisha Yusufu, what that means is that there is no definite pronouncement from the court. The court didn't say, that haven't been suspended for so and so period, and that it is that time is enough for the punishment, that whatever punishment that might have been meted out to her, and that consequently, we call them consequential order, that consequently that she's hereby recalled back to the Senate. What the court just said, that the Senate should consider, recalling. I also expected that the Senate should have made a definite pronouncement on those provisions. It's either the court is saying, you're striking out those provisions, or you're not striking out those provisions. In the absence of that, those provisions stands, and the court has ruled that the Senate has powers to discipline its members. So every other thing said would just be said in the passing, considering the fact also that originally the prayers that she requested for was not a recalling process, because as at that time she had not been suspended when she went to court, so it could not be part of the prayers that she was seeking. So that's where the whole clarification needs to come in, because a lot of people have been saying that the court had ordered. The court didn't order the Senate to recall her. Okay. From the ruling that I have seen and from the interrogations I've had with some of the lawyers that were in court also.
Okay, thank you very much for your expert insight, legal expert Liberus Oshama. Thank you for your time. Always a pleasure having you on the news.